All right. Good evening, everyone. Welcome to our regular council meeting for Monday, February the 27th. A bit of an earlier start tonight than normal because we have an education session early on in the agenda. I will call the meeting to order at 5:02 and would ask everybody who's able to stand for the playing of our national anthem. We would like to begin by respectfully acknowledging the town of Shelburne resides within the traditional territory and ancestral lands of the Anishinaabe, including the Ojibwe, Potawatomi, Chippewa, and the people of the Three Fires Confederacy. These traditional territories upon which we live, work, play, and learn are steeped in rich Indigenous history and traditions. And it is with this statement that we declare to honor and respect the past and present connection of Indigenous peoples with this land, its waterways, and resources. And we encourage residents to review the call to action information, which can be found on our website. Reminder to members to declare any pecuniary interest that they may have on any matter being discussed this evening in accordance with the Municipal Conflict of Interest Act. On to the minutes. Can I have a motion to approve the minutes from our February 13th council meeting? By Councillor Bernardo, seconded by Councillor Fegan. Any discussion on those minutes? All in favor? That's carried. All right, so that takes us to our special education sessions. We're joined this evening by our Integrity Commissioner, Guy Giorno from Fasken Martineau. Good evening, Guy.
Good evening. Thank you, Your Worship.
Well, I'll turn it over to you and you can lead us through your presentation.
So thank you very much, Your Worship, and through you to members of council and also to the clerk and deputy clerk for making these arrangements. I know it's not ideal for me not to be there in person, so if at some point sound cuts out or you can't hear me, please flag or signal. And as I said, I know it's not ideal, but it's probably better that I do this than be phoning in somewhere from the side of Highway 10. So instead of sharing my screen, Your Worship, I think what we've decided is that I will just you'll see me, and I think every member of council already has my presentation. Yep. And so I'll just refer to that. What I propose to cover today are the following topics. I want to talk very briefly about the role of an integrity commissioner, and I want to talk about how council members' roles fit into what we're talking about as the code of conduct. I then want to talk about the Municipal Conflict of Interest Act. I'm probably going to spend maybe most of the time on that. Then I want to go back to code of conduct and talk about the code of conduct here in town, and then end by talking about the relationship between council members and the staff. I'm in your hands, Your Worship, as to how long this takes. I think my view is probably better to take questions as they go along, but I'll leave that in the exercise of your discretion as to how you want to handle questions. But I'm certainly happy to be interrupted as I go along. So the
sure.
first,
I'll just try to keep an eye on questions and let you know if somebody has any.
Turning just to the background, the slide that's marked background, I've been the integrity commissioner for the town for I think 6 years now. So I know I'm not new to many, although I'm new to some. The background slide just talks about who I am. I'm a lawyer, as your worship you've identified. But my practice, as unlike other integrity commissioners who spend a lot of their time as either municipal law lawyers or municipal backgrounds, my background is a lawyer whose practice is actually devoted to conflict of interest law and government ethics laws and government accountability laws. So that's sort of how I've come to being an integrity commissioner. The role of an integrity commissioner is set out in the Municipal Act, and I know that this is known, but it's worth repeating that there are really 4 roles given by the statute. One is the application or the administration of the code of conduct for municipality. The next is the application and enforcement, in part because the courts also have primary responsibility for this statute, but responsibility for the Municipal Conflict of Interest Act. The third, and I think one of the most important functions, is being available to answer questions and give confidential advice to members of council. And then finally, there's also a responsibility to provide educational information, like I'm doing right now. I'm not an employee of the municipality. I operate independently. The Act says I'm supposed to operate independently, but I am an officer. I'm appointed to office. I'm an accountability officer under part 5.1 of the Municipal Act. So it's a very unique relationship. And I'm very much cognizant of the fact that this the requirement to have integrity commissioners has been downloaded, but it's a requirement of provincial legislation. But the province doesn't provide separate funding for this. So I'm very much mindful of the fact that while the province requires this, every municipal tax base has to support the role of the integrity commissioner. So I think that places on integrity commissioners like me an obligation to do our jobs under the Act and to do them completely, but to also to do them reasonably and efficiently, having, taking into account the fact that these are public funds being expended. The next slide says advice for integrity commissioner. And as I said, I think that's one of the most important parts of the role, because if advice is given at the front end, that can avoid a lot of questions later on. The requests that come in for advice, or at least the requests that integrity commissioner is supposed to handle in the statute, are by council members or local board members about an individual's own responsibilities or obligations. And it can be under the Code of Conduct, it can be under the Council Staff Relations Policy, it can be under the Municipal Conflict of Interest Act. I will say that most of the questions I get relate to the Municipal Conflict of Interest Act, which makes sense. The requests have to be in writing. This isn't something that I've decided. It's something that the legislature put into the Municipal Act a few years ago. And the thinking of the Act says that my response has to be in writing. And the thinking of the legislation is that there's a record. If there's any dispute about what was asked and what was responded to, there's a written record of what the request is. But I'm very practical about this. I'm aware that a lot of requests come in and need to be answered before a meeting, a committee meeting or a council meeting. So my practice is to, in the interest of time, to accept a phone call if the council member agrees to put it in writing later. And then I can follow up in writing with an answer, but I can also have a phone discussion, which might give the answer in the meantime. One thing I do ask, Your Worship, I ask people when they council members when they request advice to, if they know that there's something on the agenda for a particular meeting, to let me know when the meeting is, so that I don't want to be late. I want to be able to make sure that the answer arrives in sufficient time for the meeting, and knowing whether it's on Friday for Monday's meeting or something like that is very helpful. The next slide says written advice more. The advice that an integrity commissioner gives is basically, with a few exceptions, belongs to the member of council. So that means it's confidential from my perspective, with a few exceptions, which I'll talk about. But from the member's perspective, it's a members. You can keep it confidential. You can share it. It's up to you. In practice, most members keep the advice that I give to themselves, but some have, and you can understand why, felt that it's necessary. Maybe there's questions in the community, or there've been questions raised. Some of them have actually taken my letter or email and have tabled it at a council meeting. Others have gone, said to the news media, "Hey, I'm participating in this vote because the Integrity Commissioner says it's okay." And that's entirely appropriate. The advice belongs to the member who requested it. So whatever the member wants to do with that is fine. The Act says that I can't share that information unless I do it with the member's consent, or in particular circumstances where there's been a disclosure by the member of the information. I've only part of the information or the advice. I can disclose the rest of the advice. And in a couple of cases where there are actual proceedings under the Municipal Conflict of Interest Act, advice that I have previously given that's relevant to the particular Municipal Conflict of Interest Act proceeding can be disclosed. The final thing I wanted to say about the request for advice is the way the legislature has set up the system. It's designed to give a member advice about that member's situation, not another member of council. And occasionally a member will contact me and say, well, can you tell me whether Councillor so-and-so was breaching the code of conduct? And my answer to that is I can't, because it's not fair to that other member. You can come to me for advice on your own situation. And that's fine. You give me background, I'll give you advice based on that background. But if it relates to another member's situation, I can't really comment on that other member's situation without hearing from that member. It's only a matter of fairness. And I'm not trying to escalate things, but the way the system works is if one council member has a real issue with another council member about that person's behavior, there are ways to settle it without going to the code of conduct. But the only way to involve the Integrity Commissioner is to make an actual complaint. I'll pause there because I'm going to talk next just about the types of inquiries and investigations I conduct. Is the audio still okay, Your Worship?
Yep, we're good. And any questions at this point? No, I think we're good to go. Yep.
So inquiry is just another word for investigation. I think most codes of conduct and municipalities, we call them investigations, but the term in the Act is inquiry. It means the same thing. There are two kinds of inquiries that an Integrity Commissioner can conduct. One is an inquiry into whether the code of conduct has been breached, and the other is an inquiry into whether the Municipal Conflict of Interest Act has been breached. Now, a complaint or a request for an inquiry will come in, but the court has said this, it's up to an Integrity Commissioner to decide whether or not to conduct an inquiry. Why would an inquiry not be conducted? Well, maybe there's another process that really fits better. I mean, if let's say it's about information or something like that. Maybe it's better to be directed to the Information and Privacy Commissioner under MFIPA, or maybe it's a human rights issue or something like that really isn't about the Integrity Commissioner. Also, if the complaint doesn't discloses facts that wouldn't amount to a breach of the code or wouldn't amount to a contravention of the MCIA, even if they were found to be substantiated, that's another reason not to conduct an inquiry. I also wanted to point out, of course, that these inquiries are conducted at municipal expense. So when an inquiry is conducted, I must do it fairly and completely and properly under the law, but I also try to do it efficiently, because there's nothing, there's no benefit in unnecessarily adding to the complexity and costs of an inquiry when it can be done efficiently. I don't know. I don't remember if this. I think it's an open meeting, so there may be members of the public listening to this. I will say to anybody who's interested in, or a council member who's interested, or a staff member in, asking the Integrity Commissioner for an inquiry, making a complaint, in other words, that's a legal right. Certainly, it's a legal right that exists. The legislation says it exists, so no, people can pursue that. But I want to point out that there are alternatives as well. You don't have to do this. Some people find they can resolve issues just informally and directly with a council member by talking through an issue. there may be other ways to raise them. If, for example, there's something happening at a meeting and something is said, a point of order, point of privilege can be raised under the procedural bylaw, and a matter can be dealt with right then and there by the mayor or whoever happens to be chairing the meeting. That person has full powers under the Municipal Act and the procedural bylaw to deal with that. So not everything needs to be a code of conduct complaint. And as I say that, I do note that if you wish to make a complaint, that is your right. But there's some things that can be resolved in other means. The next slide I want to turn to is one that has two little organization charts on them. It's called complaints and applications. I hope it can be read if the print's big enough. What it does is that slide talks about the slight difference, the process that's followed for an inquiry under the Code of Conduct and the process that's followed for an inquiry under the Municipal Conflict of Interest Act. And it talks about, it shows you how they're similar and how they're different. I don't know if you're looking at color slides or not, but they're two different colors. That the flow chart or the process on the left of the page is a code of conduct breaches. It starts with a complaint that comes to me as integrity commissioner, and then one of two things are done. I will look at the complaint and say, okay, is this something that is appropriately dealt with? Is it a code of conduct matter? If not, there won't be an inquiry. Is it something that that doesn't justify an inquiry, because even if the facts that are alleged were all proven, it wouldn't be a code of conduct contravention. The thing that is complained about is not covered by the code of conduct. There wouldn't be an inquiry. Otherwise, there would be an inquiry. And what I do to start the process is to send a memo or a notice to both the person who made the complaint and the council member who was named in the complaint, and I attach to it the actual complaint. I will I'll redact the things like the personal address or the personal phone number of the complainant. Occasionally there's been sensitive medical information which I have blacked out, but other than that, the council member gets the actual complaint, knows the name of the person, knows what the issues are, and I send that along with a memo that says, there's going to be an inquiry. Here's the process we're going to follow, and here are the issues that are being considered in the inquiry. Was this section of the code of conduct breached? Was that section? So it sets things out. Sometimes there is more said in the complaint than fits within the code of conduct, or there's more said than that justifies an investigation. So this notice, this memo may also say, in fact, it often does say, these additional allegations were made, 1, 2, 3, and I'm not looking into them because they don't really apply to the code of conduct. So that's how the inquiry starts, and that document goes to both the person receiving the complaint, the person who's named in the complaint, and the person who made the complaint. If there is no inquiry, both individuals get a similar memo from me. It says, I've received the complaint's attached, personal information is redacted, as I said, but the name of the complainant's there. And it says, there will not be an inquiry into this complaint for the following reasons, and generally explains that what is said in the complaint or alleged in the complaint doesn't fit within the code of conduct. So that document, either way, is confidential to the member of council who's responding and the person who made the complaint, either way. For accountability purposes, I will, as I open a file, I will send an email to the clerk, and I will say, I have opened a file. I assign a tracking number to it. Here's the tracking number, but I don't even tell the clerk who the complaint is about, who made it, who it's against, who it's from, or what the subject is until the end. So except for the clerk to know that something's ongoing, nothing is disclosed except to the people who were involved until it's all over and reported to council. So the inquiry proceeds according to rules of procedural fairness, hearing both sides, giving both sides an opportunity to have their say, and then reviewing evidence. And that evidence can be documents, it can be interviews with witnesses, interviews with the people involved, and that proceeds in a confidential manner. At the end of the process, when there's an inquiry, a report is made. Unless unless the complaint is settled in the meantime, or unless in the middle of the inquiry I find out there really is no basis to continue, in which case there's nothing to report. Other than that, a report goes to council. Like all documents that go to council, it is submitted through the clerk, and it appears on the public. These are public agenda items, so open session items, and the report lays out the facts, lays out what the allegation was, what I found, and then it concludes with either a finding that there was or was not a breach of the code of conduct. Then that report is in the hands of council. Like every document that comes before you, it's you can do as you wish. You can be some received for information, or whatever. If I found that there was no contravention of the code, that ends the matter. If there's nothing, it's just ended, unless somebody wants to go to divisional court and challenge the finding of no contravention. If there is a finding of a contravention under the Municipal Act, the matter is then kicked over to council to decide what to do with that. And council has really three options. It can, if there's a finding of contravention, it can decide to do nothing, like no penalty, receive for information or something like that. Or it can impose a penalty of a reprimand, which is a formal, as you know, formal statement of disapproval. Or it can impose a penalty of a suspension of pay of from 1 day to 90 days of a council member's pay. But that's it. That's not none of that's the Integrity Commissioner's decision. Once the Integrity Commissioner finds a breach, it then is up to the council to decide what to do, and it's the council's exercise of discretion. Now, I will add, and there's been some court cases on this, the councils can do additional things if the code has been breached, but they can't do them to punish. They can't, so the courts have said very clearly, the Act says the only types of penalties that can be imposed in the event of a breach are the reprimand or the suspension of pay of up to 90 days. So you may have read different things people have done. Councils, have done other things. They've removed people from the chairs of committees. They may have done other things like that. And what the courts have said is that if the purpose of the other actions is to punish, they're not permitted. But if the purpose of the other actions is remedial, and that is to undo, correct, redress, remedy the harm or the impact of the contravention, that's okay. So just to use an example, I'm not just making this some sort of made up fact situation, but it's similar to what we often read in reports of integrity commissioners. Let's say there's a council member and the contravention related to a harassment of a staff, the staff or a staff member. And let's say there's a finding by an integrity commissioner that had happened and it was contrary to the code. What the courts would say is that if the council went to strip the council member of a committee chair as punishment, as a penalty, that's not appropriate. But if the rationale was to remedy the harm by for example, protecting the staff by taking the staff who would interact with the committee chair at meetings away from the chair of the committee, that remedial action of removing somebody from a chair would be permissible. So it all depends on the intention of the council and what the purpose of that is. So that's the code of conduct process. The Municipal Conflict of Interest Act process. I'll pause, Your Worship.
Sorry. Yeah, I just had one quick question. If you do have a finding of a contravention, do you customarily make a recommendation as to penalty, or are you silent on that in your report?
I customarily do not. Okay. I think I have maybe twice. Okay. And I'm of the view I won't unless council members, councils, not members, councils ask me. I know other integrity commissioners do. I don't really. I mean, honestly, I will say I work for the council. If the council thinks it's a benefit, I would do it. I'm not, having observed a lot of these, I'm not sure it ends up being of benefit to the council to hear the integrity commissioner's views. But again, I would take my direction from you. If you wanted to hear that recommendation, I would, because I'm accountable to the council. I would make a recommendation. Okay. Okay. Thank you as well. So the Municipal Conflict of Interest Act process looks similar, but there are differences to it. The significant difference is it doesn't end up with council; it ends up in the court. So I don't want to spend a long time, but council members who were council members before, and even others may remember that there didn't used to be an integrity commissioner, the process to enforce the Municipal Conflict of Interest Act. The process used to be that somebody who felt a council member had breached the Municipal Conflict of Interest Act had to, as an individual, actually it had to be an elector, so somebody entitled to vote in the town, had to go to court on the person's own, and either get a lawyer or do it personally and pay court fees and risk the fees of losing and things like that. And that's been the process for decades. It actually still is the process. The legislature didn't remove that other process. They just overlaid an integrity commissioner piece on top of it. So the old process, I mean, you can say what you want about it. I think one of the criticisms was, wait a minute, if conflict of interest law is the law is a public good, and these restrictions are part of the law of the province, why do private citizens have to be the ones to enforce it? We don't enforce other laws of the province privately. It's a public function to enforce a law. So the government heard that and introduced amendments to create basically a publicly funded enforcement process, so that private citizens don't have to be the ones to enforce the MCIA. But they did it in a very complicated manner. So what the new legislation says, or the current legislation, is that the right to go to court still remains. Anybody can go to court. In fact, they broadened the right to go to court. It used to be just an elector. Now it's an elector or anybody demonstratively acting in the public interest. And that could be like anybody. It could be an interest group based in Seattle. I mean, it could be anything, right? Could do this. So that right still exists. But there's now a second track, and that is a person can go to the integrity commissioner. So at municipal expense, for free for the person, but not free for the town, and make a case to the integrity commissioner. And the integrity commissioner can decide either to conduct an inquiry or not conduct an inquiry. From my point of view, the process starts the same. There'll still be a memo issued to the person who made the request and the council member saying, I'm conducting an inquiry on these issues and not on these other issues, or I've got this request, I'm not conducting an inquiry at all. So that's one of the two options. And then if an inquiry is conducted, it's conducted in a procedurally fair way, hearing both sides, allowing people to make submissions, looking at all the evidence. At the end of the process, the integrity commissioner's decision is not to say there was a breach or not a breach, but to say, yeah, there's enough there that I'm going to go to court and take a case to a judge. Or to say, no, I've decided I am not going to take a case to a judge. So that's the process. And it ends up, and the act says the integrity commissioner has to give reasons and publish the reasons. So it's no longer, we're out of the world. A copy of this document goes to council, but the act makes it very clear it's not like a council document. The integrity commissioner is publishing reasons saying, yes, I am going to court, or no, I am not going to court. And the court case is brought by the integrity commissioner, but basically as a town legal proceeding at town expense. And then it goes to a judge, and then ultimately it is the judge, just like under the old system, who would decide whether or not a member has contravened the act and whether or not a penalty is being imposed by the judge. Now, oddly, or not oddly, I guess to link back to the old process again, if the person who made the original request is dissatisfied with what the integrity commissioner said, basically let's say the integrity commissioner says, no, I'm not going to a judge, that person still has the right to go to court at the person's own expense, just like the old system. So that is the new system, somewhat complicated, but that's how it works. I'll pause there, Your Worship. And if not, then I'll.
Yeah, looks like we have one question here from Councillor Bernardo.
Yeah, you were saying that it can be brought by any party, individual in the Municipal Conflict of Interest Act, right? So
yes.
Originate anywhere, Canada, basically.
Or in the world, yes. The only test is, so the two tests are, if it's an elector, that's it. It can be just, the person has to be an elector, so right, entitled to vote in Shelburne. If it's not an elector in Shelburne, the person has to demonstrate they're acting in the public interest. But that's very vague and that's very broad.
Okay. And if it goes to the courts, I guess this is a question more for staff. Is the counselor, while going through this process, under the insurance covered, or is it on the counselors to defend himself?
Yeah, Your Worship, I'll leave that to the staff because that depends on the policies and the bylaws in each municipality.
So we would have to look at the breadth of the policy, but for the most part, my understanding is that the majority of actions of counselors, unless they were independent, would be covered under the policy, but the policy has to trigger an action in terms of a claim. So our policy is usually based on damages or requests for costs in order for them to consider triggering the deductible. So, but we'll certainly, I think that's a good thing. We better clarify and dig into that a little clearer on what counsel is covered under through the policy.
Well, and the only reason I raised that is if it can be brought from anywhere in the world, it can be brought directly beyond the integrity commissioner, directly to a judge. You're kind of messed up. So that's just my question.
Okay.
Don't do bad stuff.
Anybody else? No? Okay.
So the next slide has my name and contact information. And you might say, why is it in the middle of the presentation? It's just a reminder that I'm always available to answer questions and give advice, and I can be reached. Those are my numbers. They always go to my phone. And I have a dedicated email address for Integrity Commissioner things, so they come to me and I can always see them, and I encourage people to use it, but I can be called at any time. I will say that here in this town, most of my work has been, and it's been very, over the years, very, very little, but it's been giving advice. Very, very little complaint-based activity in the town. So I know, switching to the second part of the presentation, which is called the role of council members, I know, Your Worship, and through your members of council, you've heard lots about what the role of council member is. I know, I'm pretty sure that after the election, during orientation sessions that we've discussed, I'm not going to repeat that. I'm just going to talk about a few things that are relevant to what we're talking about tonight. So as you as council members know, the council is a collective decision-making body. There's no strong mayor powers in Shelburne, so everybody is just one member of a collective, and any authority exists. There's no individual authority. It's all exercised by the group of the council, and as a group, making decisions by majority vote. It is the ultimate decision-making body on behalf of the corporation of the town. Those decisions made by the ultimate decision-making body on behalf of the corporation of the town are reflected in official instruments, so bylaws, resolutions. They're recorded in minutes, and the municipal act actually says that anything that the municipality decides, council decides is to be done by bylaw unless there's another method permitted, which is why the confirming bylaw is often usually made at the end of or passed at the end of a meeting, just to catch any decisions that weren't already reflected in bylaws. There's a bylaw which says everything we just decided is given the status of bylaw anyway. The other thing that I note, as you know, is that typically councils make decisions based on staff recommendations. Right? It is possible through a notice of motion for a member to develop a concept independently and put it before council, but typically you're receiving reports and advice and recommendations, and then that council has four choices with any recommendation. Council can accept the recommendation, council can vote to amend, and then adopt the recommendation. It can defeat the recommendation either on its own or as amended, or it can table to another day, right? So that is the typical process, and in that respect, council is the ultimate decision maker. There's no requirement. It doesn't have to do any of those four things. It doesn't have to adopt a recommendation. Doesn't have to amend it. Doesn't have to reject it. Doesn't have to table it. But those are the options. The other thing that the municipal act says, I'm going to talk about the courts in a second, is that of course there's both that there's a lawmaking function. The council is a lawmaking function, but it also has a political representational function. And the not only does the municipal act say that, but the courts have confirmed that. And so the next slide just picks up on this. The slide mark, which says individual council members. It says the authority's collective belongs to council as a whole, but the courts have recognized that beneath that collective authority, in order to discharge your collective lawmaking functions and your collective representational functions, individuals do have roles. Now, none of this is in the municipal act saying, individual councillor may do these things, but the courts have said this is part of the role. And the part of the role the courts have confirmed is in communicating. That it is appropriate for council members before they come to the council table, right, to pass things, to have been talking to the people they represent. The courts have said that's a representative function, and the courts have made clear that that communication function, which individual council members can engage in before they come to the council meeting like you're doing tonight, isn't just listening. I mean, obviously, listening to constituents is important, but the courts have actually said that the two-way communication is permitted. Council members can also be in the committee talking, talking things, and not just talking about what is happening at town hall. The courts actually say that it's open to a council member to take a leadership role on an issue. Like, so, the whole range. On the one hand, it's appropriate for a council member to be listening to the community and hearing things and taking those concerns and informing decision making at a council meeting based on what's been listened to. But it's also at the other extreme appropriate, the courts say, for a council member to be the first person in the town to propose an idea and build support, to champion an idea, to build support in the town and work that way. So this is not like, there's nothing in the municipal act that says that you may go off and print brochures, or you may go off and run a Facebook page. That's not clear. But just the actions of listening and dialoguing, speaking, communicating, advancing ideas, getting feedback, those are absolutely, the courts have said, things that are appropriate for council members to do. Now, of course, when town resources are used, town resources can only be used for things that are legitimate town businesses. The next slide deals with something different, and that is this code of conduct. What is it meant to apply to? Who does it, does it apply to everything a council member does? These are your public figures. And so I give examples there from two cases I was dealing with as integrity commissioner. They're public. As I said, reports of integrity commissioners are public and documents. So these are public. The first is a case that involved a mayor 2 mayors ago in the town of Orangeville, also in Dufferin County. And the issue there was social media. Complaint was made to the integrity commissioner about the Facebook page of the mayor, and it was personal Facebook account of the mayor. So the question is a personal Facebook page, is that covered by the code of conduct, or is it not? And in that case, the facts indicated that that personal Facebook page was used to talk about town business. It was used to talk about town policies. It was used to talk about and inform people of town council decisions. And so, my view was, well, that's covered by the code. If you are using, you can say it's your personal account, but if you're using that platform in a very official way to talk about official business, certainly the code of conduct will apply to that. The other case that's sort of excerpted on that slide is a different result in a different place. This was the municipality of Clarington, which is in Durham region to the east of Toronto. And there was a case that involved a dispute between two neighbors. And the dispute between two neighbors involved the property line or the lot line, the line between the two properties. It involved a fence between the two properties, and involved plants growing on the fence. Very much so. I say that just to point out, it's a neighbor neighbor issue, two neighbors. And in the course of that, dispute, things were said and done, and a complaint was made to the integrity commissioner about the council member who was one of the neighbors. And in that case, I found there was actually nothing about the dispute, the plants and the property line and the issue that had anything to do with the municipality. There was no municipal function, there was no municipal resources used. There was an allegation, which I found not to be substantiated, that the council member had used the position of council member to communicate with the police in the dispute. And so I said that if a dispute is if an issue relates to somebody entirely as a private person and it doesn't impact the municipality, then that's not something that's covered by the code of conduct. Now, does this mean that it's okay as a matter of like municipal policy or provincial policy for people to be bad neighbors? No, it's simply saying it's not really what's covered by the code of conduct. Whether you're a good neighbor, a bad neighbor, a good friend or a bad friend, a good family member, a bad family member, where you're a good worker at your workplace outside municipal operations is not the point. It's that's not something that was ever intended to be covered by the code of conduct unless there's a municipal interest at stake. So that's the end of these introductory sections, Your Worship. And I was going to move to the Municipal Conflict of Interest Act, if I might.
Sure. Yeah. I think everybody's good.
I see we're running for time, so I'm going to pick up the pace as well. So I know council members are familiar with this already. The first thing to say with the Municipal Conflict of Interest Act is that it's a very severe statute. I mean, because it provides for the potential sanction, the ultimate sanction of removal from office and a prohibition of running for office for a period of up to 7 years. So it's a very, very, very strong, very important statute in that regard. But it's also somewhat narrow because it does not cover all interests that might cause people to be interested, or I don't want to use the word bias, but that might allow one to allege a bias. It's narrowly defined. First of all, it only applies to economic interests or financial interests, pecuniary interests, something that is related to or can be measured in money. Now, in that respect, it does apply broadly to not just your interest, but your employer's interests, the interests of bodies to which you belong, the interests of corporations you may own. It also applies to the interests of your families, but only these categories of family: spouse, child, parent. So it's narrow that way. The legislature has not covered in the Municipal Conflict of Interest Act a non-pecuniary interest such as, I don't know, an appointment made to someone's best friend from high school. That's not economic, but it certainly you might feel really attached to your best friend. The MCIA says nothing about that. It doesn't cover it. It doesn't cover pecuniary interests of relatives other than spouse, child, and parent. So, for example, does the MCIA prevent you from voting on a contract being awarded to a brother or sister? No, it does not. Does it prevent someone from voting on a contract being awarded to a cousin, first cousin? No, it does not. Does that mean the legislature is saying it's okay, to take part in awarding contracts to brothers and sisters and cousins? No, it's not saying it's okay. It's simply saying that this statute doesn't cover that. Now, if one has a pecuniary interest, or one's employer or company one owns, or a body of which one's a member, or one's spouse, child, or parent has an interest, there are 7 steps to be followed. Right. The first is to disclose the interest. The second is to pull back, to recuse, to take no part in decision making or voting on the issue. Also, not just enough not to pull back and not take part in the discussion and the voting. Also, one can't try to influence another member of council. If the meeting's a closed meeting, one has to leave the meeting. In fact, it is a practice in many municipalities, even at an open meeting, to leave one's council seat for fear that sitting in a seat could be seen, body language, as trying to take a position or exert influence on the proceeding. There's also a requirement, this is new in the last few years, to supplement the disclosure of interest with a written statement, which is filed with the clerk. Another provision, new since 2019, not just influencing other council members or committee members is prohibited, but also trying to influence the staff, even as they write their report. If you have an interest in a matter, or a spouse does, or parent does, or child does, or employer does, or whatever, one can't even try to influence the staff on that matter. And finally, there's a provision that's been there for a while, which is if you're not for some reason present at the meeting where you would have declared an interest at the next meeting that you are present, you've got to disclose the interest you would have declared, and that would be recorded in the minutes. There are two slides, Your Worship, that read Municipal Conflict of Interest Act exemptions, exceptions include. There are 11 exceptions under the Act. These are situations when one has a pecuniary interest, but is not required to do the things I just talked about, the 7 things: the disclose, the pull back from the meeting, leave the closed meeting, etc. Some of those are situations where you as residents of the town are subject to the same rules, the same services, the same mill rate as everybody else in the town. And obviously you don't have to, declare an interest in something that everybody shares. So those are some of the exceptions. I want to draw attention to the second last exception, the second last bullet on the second last of these slides. So we're looking at slide 20. It says municipal conflict of interest exceptions include. The second last bullet says members' interest, so remote or insignificant, that cannot reasonably be regarded as likely to influence the member. So that means that there is an exception for a pecuniary interest that one may have. That you don't have an interest, you do have pecuniary interest, but if it's so small, remote or insignificant, so small, insignificant, small, or remote, like far in the distance, that nobody would think it could reasonably be expected to influence you. Now that's a real exception. It's really in the Act. The problem with that is that at the end of the day, the only person who can confidently, for certain, say whether it applies is judge. So many council members will say, I think this is a small interest. I think it's not significant, but I'm not going to take the chance of having a case go to a judge who may disagree with me. So I just caution that. Yes, people, some council members will say to me, is it true that an insignificant interest does not need to be disclosed? And the answer is technically yes. If it's so insignificant, no reasonable person would think it would influence you. Yes, you don't have to disclose it. But, ultimately only a judge can decide that. So you could decide whether or not you want a chance that the judge may think that it is more significant than you do. The next slide says enforcement, Municipal Conflict of Interest Act enforcement says just these things, that only a judge can impose penalties. It talks about the enforcement process I've talked about. The next slide, slide 22, lists the types of penalties, which range from reprimands all the way up until vacating a seat and prohibiting somebody from running again. That next slide, it's now slide 23, looks at things that a judge will look at in determining a penalty. So if a judge decides there was a contravention, now the judge is at the penalty stage. Do I remove somebody from office, or do I impose a reprimand or suspend pay? The things the judge will look at include whether a member took reasonable steps to prevent contravention. I want to pause on that. What does it mean to take a reasonable step to prevent contravention? In the concept of taking reasonable measures is a very common one in law, and it exists in health and safety. It exists in environmental matters, different areas of law where, what does it mean for an employer to take all reasonable measures to ensure the health and safety of workers? What does it mean for somebody, to take reasonable steps all to prevent the discharge of pollutant into a waterway? Right? So you might say, well, how do those principles apply to this? Well, they apply the same way, except we're not dealing with machinery in a workplace. We're not dealing with environment. We're dealing with information, basically. We're dealing with information and voting, right? Those are the the issue. So how do you take all reasonable steps to ensure that your voting on the basis of information is consistent with the act? Well, reasonable steps, in my view, and I think this is consistent with the case laws, means first of all, being as familiar as you can be with your financial interests. And I'll get to the second piece, but first, so knowing, knowing where things are invested, knowing where your property is, knowing and being reasonable, having a reasonable view of what would affect the value of your property. Also, to the extent possible, I say to the extent possible, you can't make your parent or your child or your employer tell you things. They don't have to, and your spouse doesn't have to tell you things, but to the extent you reasonably can, being familiar with the interests of those entities, your parent, child, spouse, employer, bodies, so that you have as much information as possible. Because if you don't come to the conflict of interest decision-making process, doing all that you can to be aware of those facts, you haven't taken reasonable measures. If you haven't even asked what this means, as I said, they can tell you no, but if you haven't even asked the question, then you can't say that you've actually been reasonably diligent or reasonable in pursuing the information about whether you have a conflict or an interest to disclose. The second piece is they're talking about knowledge of your financial situation, and those of, to the extent possible, of spouse, parent, child, employer, etc. The second is applying that to the matter on the council or the committee agenda, and trying to determine whether or not that item on the agenda will affect the interests we've just talked about. Now, sometimes it's very clear, sometimes it's very confusing. I will say this, and I believe this is consistent with practice, but I want to make sure. You will have heard said, and it is correct, that the integrity commissioner can give you advice, but other than the integrity commissioner, it's nobody else's job to tell you whether you have a conflict or whether you have a pecuniary interest. It's your own. So you can't go to the staff and say, do I have pecuniary interest? Because it's not the staff's job. And that is correct. It's not the job of any other member of council. It's each individual's. However, when you get the agenda package, and not for person debating it or that, if something is unclear and you don't understand what this proposal is, and you need more information about the proposal to understand, like where's this lot, where is this proposal, you certainly can get information about what the agenda package means, so you can decide, oh, now I know what that means. Now I know what that is proposed. Now that I understand that application, I do know that is going to affect my parents' property, or potentially affect their parents' property value, so I'm going to declare an interest. So to make a long story short, my summary is taking reasonable measures or reasonable steps to prevent contravention means, full knowledge of your financial interests, and to the extent possible, and making inquiries, the knowledge of the other people covered by the act, and then applying that knowledge to an understanding of the agenda package to decide whether or not the two intersect or overlap. It's not enough. It's not reasonable to say, oh, I didn't really look at the map in the agenda package, or I didn't really understand what it would mean. Those aren't taking reasonable measures. I'll pause there, Your Worship.
I think we're good.
Then the other thing that the judge can take into account is if you ask the integrity commissioner and you follow the integrity commissioner's advice, the judge doesn't have to agree with the integrity commissioner. The judge doesn't even have to take, to agree, but the judge can take into account whether you in good faith went to the integrity commissioner and took advice, and that can affect, it won't affect whether you breached the MCIA or not, but it might be considered by the judge in deciding what penalty to impose. And certainly there have been cases where the judge's penalties have been harsher because the council members never bothered to ask questions and never went to the integrity commissioner on that. The last point I wanted to make, I talked about how the MCIA, well, it's a very strong tool with very severe remedies, it's narrow, it doesn't cover everything. It's open to a municipality in its code of conduct to fill in some of the gaps, like things that an ordinary person would consider to be a conflict that aren't necessarily covered by the act. And there is an example of that in the town's own code of conduct. This is the slide 24. Refers to section 1.3 that says no member shall use the influence of office for any purpose other than the exercise of official duties. That's a very broad statement, but it covers, for example, helping your cousin get a contract with the town. The MCIA doesn't, cover a council member helping a brother, a sister, or a cousin get a town contract, but a council member who did that would be acting contrary to section 1.3 of the code of conduct. So the code, as I said, the code of conduct does fill in a bit of the gap that's been left by the Municipal Conflict of Interest Act. The next several slides, and I will not go through them all. I will not, are cases by the courts, explaining what is a conflict of interest, when a member of council has breached Conflict of Interest Act, when a member hasn't. I will just go through a few of the highlights. Most recent one, the new mayor of Elliott Lake was unseated in January. For many years, there's been talk in the city of Elliott Lake about building a new multi-purpose community recreation center. There's no shovel on the ground. It's not even that far. It's only very conceptual, but there have been different locations that have been talked about. And the former mayor now, with his wife, was a co-owner of a strip mall. And the evidence before the court was that over a period of years, both in discussions with the staff and in discussions with other council members, this council member had been doing things both to promote the potential location of this recreation center near the strip mall that he owned, and to, trash talk or diminish or be unhelpful to alternative locations, which weren't as close. There was actually the court just didn't look at this, speculation. The court actually heard evidence from a business valuator, and the business valuator said, "Oh yes, if the new community center, recreation center, is in this particular location close to the strip mall, it will absolutely benefit the businesses in the strip mall and the landlord of the strip mall." So the court found this a very clear case of dealing with matters in which one had a pecuniary interest, and removed the mayor from office. It had happened when the mayor was a council member, like a councillor, excuse me, but the case was not decided until January after the election. And the judge also imposed a 2-year prohibition on running for office, which I'm not sure what that means exactly, because we have a 4-year cycle. So it does mean that the mayor can run again in the next election. The next case, it just shows the scope of what it may mean to be interfering or inserting oneself being involved in a decision which one has a pecuniary interest. That was a case in a municipality where a council member's son had been received an invoice for having a fire during a fire ban, which had to be, fire department had to come to it. The council member never did anything like related to her son's invoice for the fire ban, but she took the next opportunity when the fire chief was there talking about the fire department budget to grill the fire chief about, among other things, the fire ban, how many invoices are put out, whether the invoice, whether they, how they treat people, whether they invoice everybody, they done it fairly, like really grilling. The evidence showed really grilling the fire chief over this, and the court was satisfied that even though she never mentioned her son at all and didn't specifically talk about her son's invoice or charge imposed for the fire, that she was really trying to get at his case by just asking a whole bunch of questions of the fire department over how they deal with the fire ban generally. And the court found that affected the pecuniary interest of her son, therefore, and actually removed her from office, and that was upheld on appeal. I will skip the next Elliott Lake case, but I will talk about a few cases that talk about where there's no pecuniary interest because things are too distant and in the future. And the first example of that is the case of Duncan and Hewitt. That's a case that comes out of Haldimand. And there was a group that had been like a citizens group, that a community group for years had been trying to preserve an old heritage mill, and they hadn't succeeded. And they came to council to report that they had, that they were going to throw in the towel, that they weren't able to do this. And what the council asked for was a staff report on what it would mean to the municipality of this community group, which had been striving to save or preserve the mill, the old mill, would mean. The council member in question voted for the motion with the majority of council, and it passed, and a complaint was made saying, well, this person's father is like running the group. So the council member had an interest. The court said no. Actually, what the court did was the court looked at what it means for council to send something off for a staff to report back on, and the court noted that that motion to have staff look into things didn't affect anybody's pecuniary interest, because they weren't saying go spend money, give the it's possible. Like maybe the staff are going to come back and say, yes, we got to give $5,000 to this group to help them preserve the mill, or maybe they'd say whatever they'd say. But the court said, I wrote it right down there, that the direction to investigate is not anything more without knowing the outcome of what the staff investigation would be. And it wouldn't necessarily, you can't assume that just because the staff has been sent away to, look at a matter and report back that there will be an impact on the financial impact on the nonprofit group. Now, when the staff report comes back and the staff reports say, yeah, we think that the municipality should give a grant to this group, then the council member would have a pecuniary interest, because the council member's parent has an interest. But until then, just sending off for more information does not affect a pecuniary interest, and you wouldn't have to disclose an interest there. So that a similar example is the next case, York and Harris. It's a case out of Waterloo Regional Council, where a council member's spouse worked for a union, and the council member moved a resolution urging the legislature at Queen's Park to adopt a particular amendment to the Labor Relations Act. And this amendment was considered favorable to the wife's union, right? And so there was a complaint made against the council member, and the court said, no, the spouse has no pecuniary interest in this, and nor does her employer, the union. And the reason she doesn't have a pecuniary interest, or nor does her employer, the union, is because municipal councils don't make labor law. There's no binding effect. Passing a motion at a municipal council saying Queen's Park should do whatever doesn't affect anybody's interest. Queen's Park, the legislature, when it passed a new law, that may affect people's interest, but this is not a matter within municipal jurisdiction. So you can't say that vote at council had any effect on anybody. And I mention this because there are lots of times that councils are asked to and do pass motions directed to House of Commons, directed to the legislature at Queen's Park. And this case indicates that you don't have to declare a pecuniary interest in those, because nothing you vote on, to state an opinion on a provincial or a federal matter of policy will affect a pecuniary interest of anybody at council, or a parent, child, spouse, or employer, etc., of a member of council. I'll skip the next case and then turn to the last one. There's a case that's slide 32 called Rivet v. Braid. It's a case again from the related to a study. Township of Georgian Bay had a chamber of commerce like in the municipality. The Chamber of Commerce was located, it was a tenant of a municipally owned building. There were several council members who belonged to the Chamber of Commerce, so they were caught by the Municipal Conflict of Interest Act as members of a body. Members of the chamber share its pecuniary interests. And one of the council members had a spouse who was the executive director or the CEO of the Chamber of Commerce, so a spousal employer connection to caught. The municipality had questions about the lease arrangement with the Chamber of Commerce. They weren't sure it was the best lease. They weren't sure it was the right rates. It was So they asked for an independent third-party review of the lease. And these council members voted on it. And they were brought to the judge and complained saying they shouldn't have done it because they can't vote. How can they vote for a review, a third-party external audit of the lease that's being paid by the Chamber of Commerce when they're members of the chamber, or in one case, when the spouse of the council member was running the Chamber of Commerce? The court said again, no. Asking for a third party to externally review a lease doesn't affect anybody's pecuniary interest because nothing's actually being decided substantively. It is sure, when the report comes back, they might say, what, the lease is too low, you got to double the rent or change the rent, or you got to evict the, I mean, what council does when the report comes back absolutely might affect pecuniary interests, but simply commissioning a report, commissioning a third-party study, that doesn't affect pecuniary interests. I'll note, I don't have in the slides here, there's a case back in the 70s where a judge said, you know, that the issue was correspondence, it was receiving for information. The judge said, receiving a correspondence for information, that doesn't affect anything. You can vote to receive correspondence for information because nothing happens. Nobody's pecuniary interest is affected at all by the vote to accept or not accept correspondence for information. Now, I understand that frequently members of council will disclose the interest and not participate for wanting to be seen optically, and I understand that, but I'm simply pointing out that the court seemed very, very consistent that if a decision of council is not going to have an impact on anybody's pecuniary interest for the reasons I've identified, because nothing's going to happen as a result of that vote, they should. Now, I will distinguish that, however, from a planning process or another process where every step, every council decision gets you closer and closer and closer to an end. Those are decisions in which one does have pecuniary interest because those incremental decisions are moving further to a final result. But the examples I've talked about are not those kinds. I will skip and move to the code of conduct, Your Worship, but I will pause at this point as well.
Questions? Councillor Fegan?
Won't affect us, but out of curiosity on that case that you were talking about where there were several council members that belonged to the Chamber of Commerce. Just out of curiosity, what would happen if there was enough members of council that they would recuse themselves and then all of a sudden you didn't have enough quorum?
Yeah, so there's a provision in the Act for an application to court to deal with a situation where you're reduced below quorum. You can, so it is possible to apply to the court for relief to be allowed you to make decisions in that circumstance.
I was just thinking, because we were saying,
what do we do now? Like,
you were saying there were several on there. I'm going,
yeah.
what if there's 4 of us that are on there and this comes up? Like, that's interesting.
Anybody else? Okay. I think we're good.
Okay, thank you, Your Worship. So I think I believe I worked out with the clerk that I'd be done by 6:30. I think, is that still, Your Worship, through you to the clerk? Is that still the right time frame? I don't want to.
Yeah.
Okay, that'll work. So the code of conduct's been around for a while. It has its basis in the original county code of conduct. The first section of the code I want to draw attention to is the gifts or hospitality code, part of the code, section 1.4, and it says the general prohibition is on any fee or benefit or hospitality or anything that helps a council member personally, including food and beverage, that's connected directly or indirectly with the role of council member. The thinking, you would say, what is it? Why connect with the role? Well, if somebody's giving it to you because you're a council member and not for another reason, then that is generally not permitted. The exception is if both of these things occur. The value is less than $100 or the $100 or less, and the giving to you and the receiving by you of the gift is what's called the code refers to. This is a very common term in these rules, an incident of protocol or social obligation. So what does it mean? Those words are often misunderstood. protocol and social obligation mean that, and the basis for our, review of this is the culture in Ontario, right? So, in Canada, Ontario, Dufferin County, town of Shelburne. Well, like, what are the practices in the community? So something is an incident of protocol and social obligation when it is considered, in our culture, our social conventions, like obligatory for somebody to offer to you and obligatory to accept. Or maybe use a different way of saying it, is rude for them not to offer it to you and rude for you not to accept based on our cultural and societal norms. And so what is that, sorts of things? Well, here's an example. You're at an event and everybody, a council member is invited to speak and everybody else is having dinner. It is impolite to invite somebody to give a speech and let everybody else eat, but not invite the person who's giving the speech to also eat. So that's an example of where a social obligation is to say, please do that. So that's acceptable. Mementos, trinkets, like little ribbons, plaques, things like that. Thank you for coming. Here's a certificate for coming to open our building. Again, those are protocol makes it a requirement, or it's consistent with protocol to offer it to you, and it's consistent with protocol to accept that. Did I hear a question, Your Worship?
No, I don't think so.
Okay, sorry. But there are things that are not. So, for example, a developer, there's nothing in social convention in Ontario, in Dufferin County, that says a developer has to take a council member to dinner. And there's nothing in social convention that says a council member has to accept the dinner. In fact, it's not a requirement, right? There is nothing to be said that business discussions, business sessions, official discussions need to take place anywhere but in a meeting room. Don't have to be taking place at a restaurant or a bar. And so there's not a case to be made that the giving of or the receiving of food at a restaurant is an incident of protocol or social obligation. Now there's one exception to that, and that's what I would call the working meeting, convention. I would say that in our culture, our business culture, if people are having a business meeting, like at the town offices or somewhere else between 12 and over the lunch hour, it is not inconsistent, and in fact it is very consistent with our protocol and our social obligation to offer soup or sandwiches or salads or something like that. It's part of our, it's a convention to offer, and it's not inappropriate to accept. So I'm trying to use, obviously, whether something is a protocol matter or social obligation, is a case by case determination. But I've tried to use a number of examples, Your Worship, and through you to members of council, just give a sense of what's allowed under this and what's not permitted. Oh, the other sports tickets. Sorry, yeah. There's nothing that says, as a matter that it's socially obliged to offer Maple Leafs tickets to elected officials, right? Or to receive them in return. That's something that is those are clearly gifts or benefits. They are not things that in our culture, our political and business culture, must be given or offered or must be accepted, if I can use that. Now there are. I must add this. This is unique, I think, to Western Canada, because I don't think that I've seen this in Hamilton or Ottawa or Toronto, but there have been some decisions by similar integrity commissioners in the prairie provinces that say that when Winnipeg or Regina or Calgary are hosting the Grey Cup, it's okay to give Grey Cup tickets, and it's a part of the job for council members to accept it. But that's I don't think that precedent really it applies. It applies, and I've not heard anything similar apply in other places. I mean, that's only the actual Grey Cup game itself. There are the next slide, code of conduct, just talks about other rules about confidentiality, breach of the code, to not keep what's closed session closed, and to disclose confidential other information that's received in the course of duties as a council member. I'm not using town property, resources, staff time for personal use or during an election campaign. The next slide just lists a number of the others. Showing decorum during meeting, being diligent in participating on agencies, boards, and commissions. I will skip this list to 14 and 15, no harassment, no bullying, which I'm going to talk about a bit more under the council staff relationship. So there's a new requirement under the municipalities to have a policy on the relationship between council and staff. Now, a lot of this is already covered in the code of conduct. It's already covered in your code of conduct. And your policy makes this clear, your council staff relationship policy. The council staff relationship policy says that enforcement of that policy is by the integrity commissioner under the code. So essentially, the council staff relationship policy is like part of the code. It's certainly enforced the same way by the integrity commissioner under the code. The exception, which is built in, is that where the complaint about the relationship between council and staff, basically what's said about the staff, arises from a council meeting or a committee meeting, that's not the integrity commissioner's job. It's the job of the mayor or the presiding officer, the committee chair, for example, to deal with that problem as it happens, and not weeks later by the integrity commissioner. The council staff relationship policy notes there are a number of different rules that affect the relationship. I've talked about the code of conduct. I'll get that more in detail. I also note though the procedural bylaw talks about using offensive language against various people, including the staff. The council staff relationship policy, refers to the code of conduct. The code of conduct requires that you show courtesy when the staff are presenting. You respect the fact they don't work for individual council members. They work for the corporation of the town as a whole. That respect the fact that they make professional, independent recommendations, not based on partisan politics, but they're based on their best advice. Harassment and bullying are covered. They're brought into the council staff relationship policy. Harassment is a course of conduct that is known to be unwelcome, or one ought to know is unwelcome. Bullying is also misconduct. I want to skip to section 11 of the council staff relationship policy. This is slide 45. And this refers to interfering with the duties of a staff member, damaging the reputation of a staff member, or interfering with the enforcement of bylaws. There's a reference to functions under the Provincial Offences Act. That's bylaw enforcement. Part of the rule of law, the principle of the rule of law, which indicates that the law applies equally to all, and those who make the rules and are holding elected office and in government are as subject to the laws as everybody else. And an aspect of that, a very important aspect, is that laws are enforced independently of political direction. No politician, no federal, provincial, municipal politician can dictate, go off and charge that person, or go say, don't charge that person. And that respect for independence of bylaw enforcement is actually enshrined in section 11.1 of your of the town's council staff relationship policy. I'll just sort of wrap up by a few points, your worship, on the relationship. The staff, they work for the town as a whole. They report through the CAO, and they often have statutory responsibilities, and they give advice based on their best recommendations. Now, that advice doesn't need to be taken. It's up to council once the advice is received. And as professionals, the staff don't have a personal interest in a particular recommendation. They've done their best job. They've done their analysis. They've done their report, and they make a recommendation. They know that council can adopt the recommendation, amend the recommendation, reject the recommendation, table the recommendation. So it's part of the process, and they understand that what they recommend may or may not actually happen. And they don't take that personally. Staff don't take that personally. But also, council should receive the staff recommendations in the same light, knowing that they are dispassionate, objective recommendations, not personal. There's no personal weight behind them. So if it's quite appropriate, to disagree with the recommendation. You don't have to. I mean, if every recommendation had to be approved, there'd be no purpose to have a vote. But what it is not appropriate is to personalize the opposition. One can disagree with a recommendation, but that's just a recommendation. When the personalities behind the recommendation are brought onto the floor, that's a problem, because it's not fair to the staff, and it's a breach of the code of conduct to take a disagreement with a policy recommendation and make it about the person who wrote the recommendation. The last slide I want to refer to then is a little slide that says observations. And there's 3 little bars. One says disagreements not equal to disrespect. So council members are free to disagree. What they can't do is be disrespectful, right? So disagreeing with staff is not disrespectful, but acting in a way that is not appropriate, which means directed to the person as opposed to the substance of the policy, is a breach of the code. The staff make recommendations, the council members vote on them. This is one reason why it's inappropriate, first of all, in the code says this, as does the council staff relation policy, to try to interfere at the level of what the staff are putting in their reports. Right? That's not appropriate. It is up to the staff to decide to make their recommendations. But I also note that it's not necessary, because at the end of the day, council doesn't need to make the recommendations, because council gets to vote on the recommendations, and that's the decision. The staff recommend, and they don't, without interference by the council, and then the council does what it wishes with those recommendations. It adopts them, it amends them, it doesn't adopt them, it defers them to another meeting, and because council has all those options, it doesn't need to and shouldn't interfere in what those recommendations are. The way to deal with a recommendation that a council member feels is not right is not to try to interfere in the writing of the report, but to move an amendment on the floor of the council meeting, which is a lawful and permitted activity. And finally, I note that personalizing things, harassing, bullying, not appropriate, contrary to the code, but upholding accountability and a transparency, which is a requirement, or it's an obligation or duty of the council under section 224 of the Municipal Act, is perfectly appropriate. So, giving direction and upholding accountability, those are absolutely appropriately the functions of council, and those are distinct from harassment and bullying, which are not. So I thank you, Your Worship, and through you, the council, for your attention. I don't know if there are more questions, but I'm certainly, if Your Worship, if there are, I'm certainly happy to entertain more.
Don't see any, so thank you, sir. We covered a lot of ground tonight, but I think that was helpful, and would certainly recommend to the council, some of those cases, go back and take a look at that, give some real life examples of where people have maybe run afoul inadvertently or inadvertently. So thanks very much for your time, and hopefully we don't have to engage you much.
Well, thank you, Your Worship, through your council.
Yeah. So with that, can I have a motion to receive the presentation from the Integrity Commissioner for information? Moved by Councillor Sample, seconded by Councillor Guichardi. Any discussion? All in favor? It's carried. All right. Thank you, sir. Why don't we take a 10-minute break, just because I know we have some presenters coming in, make sure they have enough time to all get here before the regular start time, and give us a chance to stretch our legs too. Yeah, that's